The Constitutional Court has dismissed with costs the ANC's final bid to appeal the ruling ordering it to hand over its cadre deployment records to the Democratic Alliance. The governing party turned to the Apex Court after the Supreme Court of Appeal in September last year dismissed with costs the ANC's application for leave to appeal, citing no reasonable prospects of success. The ANC was attempting to appeal the Gauteng High Court in Johannesburg's dismissal of its bid to appeal an earlier ruling ordering it to hand over its cadre deployment records to the DA. Benedict Phiri is a legal analyst and joins us live now to discuss this. Thank you so much for your time, Benedict. The court saying that the condonation, because they were also looking for that as well, that it is granted but leave to appeal is refused. What does it mean?
Yeah, it means that the court basically allowed the ANC to file its court papers outside of the prescribed time periods. But at the same time, the court found that there were no prospects of success, or the interests of justice, rather, did not favor that the appeal be heard. And I think that's the correct decision because, the ANC's challenge, or rather defense of this challenge by Mr. Phiri and the DA, lacked a very important component in that, they didn't ever in the proceedings actually challenge the fact that Mr. Phiri said that he needed this information for the purposes of bringing this bill in Parliament. So because they didn't challenge the reason for which the information was sought under the Promotion of Access to Information Act, they were never going to be successful in this application.
Now, the party is saying that it has noted the judgment and will study it and ensure that it is adhered to accordingly. So does it mean that they now have to hand over these records to the Democratic Alliance, or could there be room to maneuver?
There's no further room to maneuver. This is, a constitutional court order. And it means that the records must be made available within the time period that is provided. So there is no further room for maneuver for the ANC. Those records must be placed in the hands of Mr. Phiri and the DA.
So does it then is it clear as to what then can the DA do with these documents? Do they stick to what they told the court they want to do with them, or can they release them to the public for us to see? Is there anything barring them from doing that?
Well, the reasons for which the record were required insofar as the Promotion of Access to Information Act request was really for the purposes of this bill. Given that the bill, it will be a public process, essentially because it's a parliamentary process, I'm imagining that we will start seeing these records in various forms. It's obviously, it depends on what's in the records. Not every record can just be willy-nilly shared with everybody, but certainly I do expect that we will see some of these records in public at some point or another, given the reason for which they were requested, which was for the purposes of enacting legislation.
So what happens now? Because the DA says this ruling will, ensure transparency, but what implications does this then have for political parties going into the future, as well as ordinary South Africans, when it comes to access to information?
I think, the court is making it clear in this particular instance that, as long as a person who requests information can fit into the four corners of the Promotion of Access to Information Act, or the grounds for which information should be granted, that should always be granted. So I think the court has affirmed a principle that we lawyers and many others have come to understand on how PIA works, that provided you can establish and indicate in this instance the right for which that information is required with particular sufficiency, then there should not be a bar unless, for instance, the information relates to private individuals' personal information or other sort of commercial information of other parties, etc. But I think the court is really just giving effect to a principle that is well understood, that if you can come within the four corners of PIA and there isn't an exclusion, that information would be given to you.
So the Democratic Alliance still has that matter, which is a separate one to this one, that it has brought to declare the ANC's cadre deployment policy unlawful and unconstitutional. Now, one wonders, with these particular developments, should we read that it could be more of, leaning towards the DA's case, or could that still go anyway at this stage?
Yeah, of course, that's a separate matter because that relates to the declaring of cadre deployment policy as unconstitutional. I think what you may see happen, depending on where that process is, and I haven't checked on it, is that the DA may want to supplement its papers to actually show that, in fact, this is unconstitutional, depending on what comes of these records that will be in their hands. But if these records don't show anything that would assist the DA's case in that particular respect, then it wouldn't have an impact and the matters would continue separately as they've been continuing. But if you should see proof rather of unconstitutionality, then I do expect, if the proceedings in those matters allow, that the DA would want to supplement their papers to add this proof, to the extent that it might result in a finding of unconstitutionality.
So as a final question then, what happens if the papers are not submitted within 5 days? Possibly we could see a contempt of court, application being filed there?
Yes, if the matters are not submitted, if the papers are not submitted, the records are not submitted within 5 days as ordered by the court, then you could potentially see a contempt of court application. Obviously, there might be a reason for why they're not submitted within 5 days, but assuming that there wouldn't be a good reason or justification for them not to be submitted within the time period, then certainly there would be grounds for a contempt of court application.
Thank you so much for breaking it down for us and our viewers so that we understand exactly what is going on here. So I guess we all wait and see in 5 days' time what happens then. Thank you so much for that. That was Benedict Phiri, a legal analyst.